Ryan P. Mulvaney, lawyer, litigation, sports, NCAA, NIL, entertainment, Stevens and Lee. We had him on, NBA agent. We had Ryan on. It's been a few weeks ago, and we had a tremendous amount of feedback because of his segment with us, and he joins us today in his office. Craig Smoke, David Smoke. Ryan, hey, man, so how many, like a normal week for you as an attorney, as a lawyer, do you do more mediation or do you actually go to court very often?
Court very often. As a matter of fact, we'll be filing a brief later tonight in a case pending here in New Jersey, not related to sports, but more so in court. We try to resolve things, of course, but you need cooler heads on both sides for that. So more often than not, we're in court. Well,
appreciate your time. Good to see you. And with all the stuff you have behind you in the office. So your tweet yesterday evening, I believe, well, it only took a week. As we all predicted, Judge Wilkin granting final approval, but now Title IX mandates. How much of a cholesterol or clog can the Title IX part be going forward?
It could be a huge problem. You see already there's an appeal of Judge Wilkin's decision. The appellants are arguing that they should share equally in the back damages award, and there's $1 billion delta. I think it could be a big problem going forward. And look, we'll see this not only as it relates to the appeal here, but we're going to see this, I think, across the board in terms of revenue sharing with universities as well.
So Title IX, help me with this, because Title IX is about the opportunity to play. Is it also about equal opportunity to be paid?
Well, it's a great question, and that's what we'll find out. So Title IX effectively says an equal opportunity, yes, to participate, but that participation is broadly construed to not only include, number of sports, but opportunities to participate equally with respect to the medical staff, with respect to the meals and nutrition, and things like that. And then when we get into dollars, we talk about the value of scholarships, right? So if you're going to have scholarships, they have to be equally distributed to be compliant with Title IX. Now we're stepping into new waters. Does Title IX require that schools will have to share equally revenue that is derived unequally? That's going to be the main question going forward.
Ryan, also this question about, back, what was it, a month or two ago, we started to hear about athletes being told their roster spots would not be available. And then the approval occurred. And then there's like some sort of, I don't know if you can go back and offer whatever. So how much of that is a part of Title IX too? Not to mention just kind of a mess.
It's a mess. Not necessarily a Title IX mess, but just an all-encompassing mess. We have situations where the school under the settlement agreement is essentially the arbiter of whether or not they're going to designate an athlete who has now lost a roster spot as a result of the settlement, a designated student athlete, or as I like to call it, a DSA. And in my opinion, that presents a little bit of a conflict because you have to rely on the good faith of the university and the coaching staff to actually make that designation and put that college athlete on the list that each school is required to prepare. I'm seeing now, just this week, instances where coaches are disinclined to put athletes' names on that list because, as some athletes are hearing, you present a competitive advantage to another school. And worse, if you transfer to a school within the same conference, you now present a competitive disadvantage to me. So there's going to be a lot of movement, I suspect, in the next 20 to 25 days on this issue, because those lists have to be published by the schools within 30 days after the final approval, which occurred last Friday. So we're talking about July 5th or 6th.
There will be lawsuits every day, right? Or at least constantly coming up if they even have one that's ruled on, Ryan, and then it turns out here comes somebody else from a different angle.
When you view the glass half full the little things become magical. Like kicking back and sharing laughs, spread good vibes, and they'll come back. Celebrate what you love with what you wear, even if what you love is kind of weird. Life is good in super soft tees that spark smiles and connectivity. 10% of profits go to help kids heal. So choose optimism and make the magic real. Visit lifeisgood.com.
Yeah, we'll have, so I think the process here, at least with the DSA issue, is we'll have to proceed before the Northern District of California. Judge Wilkin has appointed her magistrate judge in the ordinary course to preside over issues related to the settlement as a special master. So things like that, whether or not someone should be DSA'd, I think will go not a separate lawsuit per se, but will go for resolution before the magistrate. Other issues, certainly, they'll be litigated. I mean, obviously, we talked about the Title IX issues, but I suspect not necessarily litigation, but certainly arbitration when we then get into these third-party NIL deals with this new structure in place with the College Sports Commission and with Deloitte.
So there was just congressional a committee or hearing like this week, and it seemed like they may have gotten one question, topic, or comment into it, and all of a sudden it's either Republican, Democrat, left or right, elephant or whatever. They didn't even get, and it's like the 14th hearing they've had.
Yeah. Yep,
how many is it going to take? My God.
Yeah, 14 hearings and counting. I sense a lot of this is more performative than anything else. You know, the joke is usually if you don't want anything to get done, put two lawyers in the room across the table from each other. But now, I mean, it's like a step above. Now we have politicians, and certainly nothing's getting done there. But you know, in all seriousness, I think a lot of the politicians have taken this up. I think maybe for attention purposes, who knows? But in the grander scheme of things, something needs to be done, whether at the congressional level or within the NCAA or whatever entity comes out of, you know, what the NCAA is today, to provide some uniformity here, not only with respect to the things that are going on that we hear about on a day-to-day basis, but also with the NIL agents and things like that. I think there needs to be some semblance of uniformity. I operate obviously as not only a lawyer, but as an NBA agent. And I can tell you that we have uniform player contracts. The only things that change are the name on the front of the contract on page 1, and then the exhibits that are attached thereafter. Everything else in the middle, standard. We have standard player agent contracts in the NBA. Everything is standard. I can't change it. I can't even cut and paste it and put it on my own letterhead. It has to be in the form and in the substance that has been promulgated by the National Basketball Players Association and agreed to and collectively bargained. And then, of course, you know, we have what we don't have in college sports is collective bargaining.
Why? And I know that's like probably a very simple, because Paul Catalina's been a part of it. He's just out for the couple of days, and he always has his take on it. But for someone like me that's not like into the legal work, why is that such a problem?
Well, first and foremost, I don't profess myself to be a labor law expert.
Right.
We do have an employment and labor group here at the firm, and of course I've talked their ears off about this issue for a variety of reasons. I think all of the conferences are not on the same playing field.
Yep.
The ACC and the A10 are not on equal footing. The football conferences and schools obviously drive the bus here, followed by basketball. So there are a variety of, I think, industry and practical reasons. But then there's the issue of whether or not you can have collective bargaining across the board in college sports, because the National Labor Relations Act, for example, applies to the private sector, But in college sports, we not only have private institutions, we also have public institutions and religious-based institutions to which the NLRA it doesn't necessarily apply. So there are a lot of legal hurdles as well as practical hurdles that will have to be overcome for any collective bargaining.
How many years have you been practicing?
22, 23 years.
How much has sports law, and you're an NBA agent, obviously, but how much has the last 15 or 20 years, or even the last 5 years, changed how much you're involved with sports law?
Well, certainly in college, within the last, I would say, 6 years or so, it has changed dramatically. I've always had a hand in sports law over the years, whether through the NBA or representing. Look, I'm an attorney by trade who also happens to be an NBA agent. So I've represented athletes in a variety of sports and in a variety of contexts most of my career, whether it's with respect to business issues or litigation issues, or unfortunately in some instances criminal issues. But certainly within the last, I'd say 5 to 6 years, college athletics, it's pretty much taking up most of my day.
It is amazing because I remember in 81 when I started television, but when I got into sports talk radio, Rod, it was 1990, and there just was none of this. There might have been an argument about whether Pete Rose should be banned from baseball, but it just seemed like it was mainly about sports.
Right.
And it really has just changed so much.
Because I think back then it was. And look, I was a senior in high school in 1990. I was getting ready to graduate and head off to Seton Hall University, great Big East school.
Yep.
But even on the campus of Seton Hall, I wasn't walking around thinking, wow, the basketball players here are really generating a lot of revenue for the university. I think what's really put this into the forefront are the billion-dollar media rights deals. Every conference seems to now have its own television station. The SEC network or the Big Ten network, even the Big East, although it doesn't have a television channel, it has a media rights deal with Fox Sports. So I think with all of this generation of revenue, I think it's really put it at the forefront here.
I've seen, and Darren Heitner, I know, has been representing athletes, and I'm sure you get calls too and are a part of that.
Yep.
But I've seen the NCAA, which is like, for the last, seemed like decade, but I've seen them win some eligibility suits, like a lot of them. The University of Tennessee player, Ziegler, really good player, trying to get a 5th year. I didn't think Pavia had a right, but then again, he won. And then there's others. What's going to happen there, in your opinion? Is that going to be just based on case by case and what they find?
Right now it's case by case and what they find. I think the NCAA should step in and have some sort of blanket decision on this issue. But yeah, we're going to have, and Darren and I spoke within the last month about a potential of us engaging with him in litigation here in New Jersey on behalf of an athlete. But right now it's a case by case, player by player scenario. You've got not only the substantive factual issues of what the eligibility issues there are with respect to the specific player, but you also have the emergent aspect of things. These cases are filed on an emergent basis by way of what we call an order to show cause, seeking an injunction, and those things are filed nearly instantaneously. When we get an order to show cause in to do, it's practically all hands on deck. We're here all-nighters, and we're filing the application within 2 or 3 days. Because there's a need, there's an urgency there. So the NCAA has won on some fact issues, but more often than not, whether there is an emergency such that an injunction should issue before you even really get to the whole merits of the case.
What do you think? You think that at some point, 5 years from the time you enter college, no matter what level, that's how long you have to play? How do you think that? What's probably the best answer to that?
That's a great question. To truth be told, I really don't have an answer to it just yet.
Okay. Yeah.
And I'm not going to, just obviously make one up. But certainly the NCAA does need to step in and say, look, this is what we're going to do, particularly for the JUCO athletes. They should have an opportunity to extend, quote unquote, their playing time and earn whatever compensation they feel like they can earn. And we'll see what happens.
Last thing, if you don't mind, and we hope to have you on down the road too. Hopefully some of this gets ironed out. Ryan, how did you get into law? What was that? Was that a part of your background, family? How did you get into being a lawyer?
I followed in my father's very, very large footsteps. So unfortunately, he's no longer with us, but I'm proud to say, as we fast approach Father's Day weekend, that I followed in my father's footsteps. He was a litigator. He practiced construction and surety litigation across the country. So I had an opportunity to grow up to watch him as a lawyer and then assume, I guess, the role myself and follow in his footsteps. And frankly, it gives me great pride because in my office here is his office furniture.
No kidding.
So
That's
every
awesome.
day I come in and I sit, the law firm that he co-founded many years ago was nice enough to provide me with his office furniture, the very same office furniture and chair that I used to sit in as a little kid when I had some hair on my head. So it gives me a great sense of pride every day to come in to the office and sit at the very desk at which he sat and in the very chair in which he sat for 30 years as a lawyer.
Man, I appreciate you bringing that up and sharing that with us. Last thing from me, you have wins and losses in sports, right? Now you have all this other stuff legally. What is it like? How do you compare winning a case or getting a settlement for your client, no matter what it's for, and then sometimes when it doesn't work out? Is the emotional roller coaster when that occurs?
Yeah, look, sometimes, and my fiance will probably tell you, I take a lot of this home with me because, look, no different than representing an athlete, whether in the NBA or in college. You're supposed to take, personal pride, not only in your work, but you need to step in the shoes of your clients. And sometimes when they're big corporate clients, it's a little harder to do, but nonetheless, you need to stand in their shoes. And sometimes you take a loss and it's a little painful. No one likes taking a loss at all, no matter what it is, whether it's in the law, sports, or anywhere else. But look, for the losses, we're able to celebrate the wins and celebrate the settlements where, as they say, everyone loses. So,
yeah.
And so long as you do a great job for the client, the best that you can do, and bring your best to the table every single day, you should be fine.
Appreciate your insight, compelling story about your history with law and also Father's Day weekend. Thank you very much, Ryan. Appreciate you.
Thanks for having me, and happy Father's Day to everyone out there.
Yes, sir. Ryan Mulvaney's been on with us a couple of different times, and also in in law because of his father who was incredibly successful. Glad I brought that up with him.